So you've got a theft charge. This can be scary. It could be anything from shoplifting to petty theft, grand larceny. There's a whole bunch of different scary words, but we're gonna talk about how to beat it. Being charged with theft can feel like the end of the world. It can follow you when you're trying to get a job. It can keep you from getting an apartment. In this video, we're gonna break down what the prosecutor needs to do to convict you of a theft charge and how you can defend yourself if you are innocent. The first thing that the prosecutor has to do is link your identity to the case. That means if they have some grainy security footage at a Walmart, they need to be able to prove that that footage is of you putting those socks in your backpack. Identity can be proved with photographs, eyewitnesses, or confessions. In the modern age of cell phones, identity is usually going to be one of the easiest things for the prosecutor to prove. But remember, if there's the possibility that it wasn't you, you only need to cast a reasonable doubt. Hey, your eyewitness said it was a red shirt. Hundreds of people have red shirts. Thousands of people have red shirts. It wasn't me. The second key element to a theft charge is intent. It's not enough that you had the backpack full of socks. They have to prove that you intended to leave the store. Now, they can do this by saying that you hid the socks, but you also might have an argument that you couldn't find a shopping cart and you planned on walking to the checkout aisle to pay for those socks. Intent is very tricky. We're not psychics, we're not mind readers. So the court will look at the entire weight of the evidence, what you said, the circumstances around your arrest, what eyewitnesses said, what you say after you're arrested can all go towards proving intent. Remember, if you're arrested, the first thing you need to do is stop talking and hire an attorney. Cops, prosecutors, the judge, none of these people are on your side. The only person who has your best interest in mind, the only person who's going to fight for you is an attorney. If you need help finding one, call the number below or go to notyourlawyer.law and we'll get you set up with a local attorney that will fight for you. If you can create an alibi around intent or an alternative intent, you merely wish to borrow the item, you wanted to compare the item to something else in the store. If you can cast doubt on any intent other than I intended to steal, you can put a serious wrench in the prosecutor's case. This one almost never comes up, but a third defense is consent. If you had permission to take an item, it's not theft. Where do we see this? A lot of times a car will be reported stolen and it turns out it wasn't really stolen. Someone borrowed it and then they borrowed it and they kept it for too long. And this happens all the time. Well, is a car stolen if you borrow it and you don't give it back? The answer is kind of complicated, but it proves how consent can be used as a defense. You stole my car. Dude, you gave me permission to use your car. This is how consent comes into play. This can also be known as the permission defense, and it applies to proving that you did not intend to permanently take this away from the owner. The fourth way to beat a theft charge, and I love how this lines up. I said that in the other video, by the way. If you ever have a drug possession charge, check that out. Don't forget to like and subscribe. We bring you a ton of educational, legal content, and we help real people with real problems on our interview series. The fourth way is through your constitutional rights, like the Fourth and Fifth Amendment. The Fourth Amendment protects you from unreasonable seizure, meaning that even if you were guilty of theft, if a loss prevention officer or a cop grabs you and they don't have probable cause and they strip search you and they find a stolen item, if they didn't have the right to do that, if they violated your constitutional rights, we can get anything they found thrown out. And without stolen goods, you can't have a conviction. Not only does this apply to search and seizure, but it also applies to your Fifth Amendment right, which is why you should never talk to the cops. You should never talk to the loss prevention officers. You shouldn't try to smooth talk or, clever wit your way out of the situation. Anything you say can and will be used against you. It's part of your Miranda rights. You have a Fifth Amendment right to just stay silent and let them do all of the work. The only thing you should be opening your mouth to say is, I want to speak to my attorney. I need to speak to my lawyer. If they keep pushing you, they threaten you, and you end up confessing or giving away information, all the things you say can be thrown out if they violated your Fifth Amendment rights. That's it. I can only speak broadly about theft charges in this video because I don't know the facts of your case, but if you want to jump in the comment section and start a discussion, it'll be very interesting to see what you guys are facing in terms of charges, and then also what states and cities you're in. As always, remember this channel is called Not Your Lawyer because I'm not your lawyer yet. Maybe one day we'll work together on something, but until then, I'm providing these for educational benefits. If you like this video, don't forget to check out our other ones. We have a drug possession video, street fighting videos, eviction videos, and one of my personal favorites, a whole bunch of Karens acting crazy. Until next time, remember, not your lawyer. You know, one time a girl stole my heart. I love you, honey. You want to talk about theft? Russell Westbrook's last contract. $50 million a year for what? What?